SJC-12240, Derek L. Young v. Joy G. Young.
Mr. Lee, good morning.
Good morning. May it please the court, my name is David Lee, and my partner Jessica Rubin is with me. We represent Derek Young, the appellant in this matter before the court. There are a number of errors which we have raised in the brief, which we contend were committed by the trial court below, but I'd like to focus on the one most egregious one, which is the determination made by the trial court that the alimony order that it set was one that was purely based upon a percentage of what it is that my client's income was and what it is that it may be at any point in time in the future.
Do you agree that there's no base alimony set?
Correct.
So that it could go either way?
That's correct.
If your client didn't do so well financially, then neither would the wife?
I agree that that's one of the problems with the order, the way it was issued. The order was issued without regard.
Before you get warmed up, help me with this issue. Let us imagine that we had Bill Gates before us. I'm sure he has a very happy marriage. And the wife receives some substantial sum in alimony. Do we measure how much she gets in terms of how much he is earning, or do we measure how much she gets in terms of how much is appropriate for her lifestyle before the divorce?
The standard of law in Massachusetts has always been that alimony is based upon need. And this court, in the case of Hines versus Letus, made it very clear that in the absence of need, there is no alimony to be ordered.
Well, need is a relative concept. So when you say need, how do you measure need? Do you measure need in terms of maintaining the lifestyle that the spouse had during the course of the marriage, or do you do it in terms of more basic human needs?
No. It has always been determined by this court that need is measured by the lifestyle that the parties had during the course of the marriage. And that's been found in Hines and Letus, it's been found in Haycock, it's been found in Gottsagen. All of those cases have made it clear that it's the lifestyle that was maintained during the course of the marriage. But that is measurable, and that is identifiable by amount, and that has historically been referred to as the need of the recipient. And what's most important here is that the order that was issued by the court was irrespective of future need. It was based upon a percentage of whatever, without limitation, the income level of Mr. Young would be. It was done without regard to what it is that the circumstances were at the time that the order was issued, as called for by the statute. And you'll find in the facts of this case that the court specifically found that the expenses that were identified on the financial statement of Mrs. Young were in fact inflated, they were overstated, they in fact included non-recurring expenses, and some of them were in fact met from an escrow fund which the parties had agreed be set aside to meet a specific purpose. Now in this particular situation, the court found that the wife's needs, that was her marital lifestyle, warranted an amount which was approximately $450,000 a year. But in fact, the order which was issued placed no cap on what it is that the amount was that might be received as a multiple of 33% of whatever it is that Mr. Young might earn at any point in time going into the future, and without any consideration of what it is that she might have if she had any income herself at some point in time in the future.
So let's take the $450,000 as what you, I guess, contend to be an appropriate statement of need.
I see that as a finding by the court of need.
Okay, so you don't need to adopt it, but you can recognize that it was what the court had found at one point in time. Let us imagine that we have a somewhat different financial circumstance, one which is more common than this one with the other 95% of us. And that is somebody, say, who's a salesman. He works on commissions. The commissions are not the same each year, or a lot of his income is obtained through a bonus. And he says, some years I can do 450. Some years I can't do 450. Some years I can do 550. Are you saying that a court may not adopt some percentage in lieu of the fact that a strict 450 may mean that a particular individual may have to get a line of credit or borrow money during lean years because the income is not a straight line?
What I'm saying, Your Honor, is that the statute says that the support order that is to be issued is to be an amount, and it is to be issued based upon need, and if in fact there is going to be any change in that, then it's incumbent upon the person seeking the change to obtain it through a modification.
Well,
In
that
this
gets
particular
expensive.
case,
So you're saying that with regard to my salesmen working on uncertain commissions, that every year they have to go back and say, I had a bad year or I had a good year, and then adjust the amount each year?
no, I'm not saying that.
Okay, what are you, it sounds
Because
as if
what
you
I'm-
are, so.
Because what I'm saying is that in the first instance, what I said is what it is that the law is. But within the statute, it provides for a deviation. The standard of deviation is that which it is that may be necessary in this situation under 53E. If in fact a court finds in a situation like yours that it is necessary, given what it is that the representations are with respect to how it is that somebody may be compensated, that in that particular case, in order to address the needs of the recipient, and in order to be fair to address the ability on the part of the payor to pay, that there has to be something done that is different, then the court can do that. And that's why the deviation provision is there. But in the first instance, you have to address the elements of the statute as they are provided. There's a definition in section 48, which says specifically that alimony is a payment to be made by one party with the ability to pay to somebody in need of support. Need is the thread throughout this entire statute.
Do we take into account that perhaps the judge below would consider fluctuating income of the payor spouse in setting an amount?
I don't believe that there's anything that is stated in any of the findings or in the rationale which would suggest that she considered anything other than the expectation that Mr. Young's income would go up. But in fact, as was pointed out by Justice Gantz, there's a possibility that the income would go down and that would affect the recipient differently. But the court has to be the one in place, in my view, to address what it is that is appropriate in the event of a modification. Because the statute, when speaking of modification, does not say that in fact a modification will occur upon somebody having a dollar amount of income greater than they had at the time the judgment was originally issued. If the legislature had intended that, they could have said that. They could have said that the definition of alimony is a payment by somebody with a greater amount of income to somebody with a lesser amount of income at a particular percentage. They did not say that.
Mr. Lee, how does the court do this? What comes first, the spouse's need, and then the judge looks at what the other spouse can pay, or does the judge look first at what the spouse can pay and determine the need? I don't know how that formula works.
Yeah. Well, the law has always been, and I think we're talking about something that's more than 50 years old, that need is what it is that serves as the basis for alimony. And the definition in the statute is clearly that the ability of the payor to pay to meet the needs of the recipient.
Okay, so the court
Need is
starts
the
with the
focus.
need.
Correct.
And what the other spouse pays depends on how much that person can pay of the need that the other spouse has. Is that right?
That's correct, with some limitation, because in section 53B, it says specifically, and these are qualifiers of meeting that need, that generally, that the level of, the amount of alimony should not exceed the need, and it shouldn't exceed 30 to 35% of the difference between the parties' incomes, determined at the time that it is that the order is issued. That 30 to 35% is not an invitation to a court to say, just pick a percentage between 30 and 35, impose it on the payor, and whatever it is, that amount of money is that the payor earns has to be paid to the other party.
Can we get back to how you decide what need is? Doesn't, need change with time? It's not a
If
static concept. So you're saying that the statute requires that it be made into a static concept
No,
at
I'm
the
not.
time of the order, that it is what it is, and then if that were to change, then you come back and seek a modification.
That is correct. That is
But-
correct. And specifically,
But
in-
if the need, I know you're challenging the evidentiary foundation for the finding that there was this trajectory. But I had the sense from that there was a sense that the judge had that the parties, what they needed changed with how much money there was to spend.
But that is not a determination that is made at the time the order is issued. That is a determination of conjecture and speculation. And if, in fact, there is a future increase in the income of Mr. Young, and if, in fact, Mrs. Young's needs had increased from the period of time that the order was issued, there might be a basis for her coming in and saying to the court, just like has historically been done before this Alimony Reform Act was enacted, to say, my needs have increased. I have
But
a
that
greater
is-
need for money at this point in time. And he has the ability to be able to meet that. And that's the essence of a modification action.
I get that, except that I guess what I'm saying is, I think the judge was tuned into the fact that these people lived in a fashion that how much they needed depended on how much there was to spend.
That's
and
not a
that-
determination of need.
Well, okay, but it has to do with the lifestyle during the marriage, and that is how they lived during the marriage. When he earned a huge bonus, they got the house in Nantucket. They adjusted their lifestyle to whatever it was he brought home by way of money.
Everybody, I think,
And in that, so it's a floating concept of need. It's not,
I think that everybody, though, who enters into any career hopes that they're going to make more money along the way. And most families, when they have more money to spend, they spend the greater amount of money that they have. That is not a basis for saying that we're going to change the history of alimony, and we're going to change the ability on the part of the court to reflect upon the circumstances of the parties at any given moment in time after a judgment is issued and determine whether it is appropriate to make a change. The statute is very specific with respect to 49E, where it says general term alimony may be modified, and this is a statutory direction. It may be modified upon showing of a material change of circumstance which warrants modification. Those are two elements. A material change of circumstance, so it's not a dollar change or a $2 change or a $100 change necessarily that automatically results in somebody else getting more money,
Is
which
there a
is what happens
carve-out?
here. But
But
may-
finish it, please
may I
finish
just
your
finish this
answer.
one?
Please
one-
finish your answer.
But the second point is that even if there's a material change of circumstance, it has to warrant a modification. And it may not warrant a modification as the court considers what the circumstances at that moment in time are of both the payor as well as the recipient. So with the introduction of a fixed percentage being applied, as was done in this case, you take away the human aspect of the judicial system, which has always been one of the landmark considerations, of course, in our wonderful judicial system. And that is you just turn judges into automatons, saying, take out your calculator, figure out what a percentage is, apply the percentage, and whatever somebody earns at some point in time in the future, apply the percentage, and that's what gets paid to the other person. That is not the definition of alimony, never has been, and shouldn't be. And the dangers of having a definition like that are great. I was very surprised to see the Women's Bar Association's brief where they were suggesting support for this type of approach, because in fact what you do is you basically put the fox in the chicken coop to determine what it is that somebody's future income may be. You let them manipulate how it is that they may describe their income or choose to construct their income, and it would be almost impossible to be able to have a contempt action brought against somebody who is subject to this type of an order. Because in order for there to be a contempt, there has to be a clear and unequivocal order that is issued. When you just say, pay a percentage of what it is that your income is, with all sorts of definitions of income, you could have a sub-S corporation where somebody has less distributions than what it is that their actual income may be, and there may be good reason for that. You may have somebody who files a Schedule C, where they have all sorts of personal expenses that are included within their deductions against their gross receipts, and you're going to get into all sorts of fights and arguments about what it is that constitutes income for the purposes of ever being able to set straight whether somebody has violated an order or not. If you have an order which says pay $1,000 a week, or whatever it may be, if you can't produce checks showing you paid $1,000 a week, you're going to be in contempt. If you have an order which says pay 33% of what your income is, we're going to get into litigation all the time over what it is that somebody's income was and what it is the basis was under which they contend that that's what their income was. And I apologize.
Sorry, I
Justice
think you may have run out of
I
time.
did. Okay.
That's right.
Well, let's take your premise then of we're talking about the time the order issued. Does the case law as it exists in Massachusetts now have special circumstances, like in the Stanton Abbott case and in the Wooters case? And I understand that the spouses were in different countries, and in Wooters that the attorney had an illness and had actually requested the percentage. But nonetheless, are there special circumstances? And if there are special circumstances, should they apply here when you have all this unvested money in the out years that the work may have been done during the marriage?
Well, first of all, I wouldn't contend that the work was done during the marriage, because the work that was done during the marriage, in this case, which resulted in the receipt of a property division.
I know,
was
but
a reward that was-
you're aware of the Ludwig case that just came out, I
Yes.
think. But forget the last part of the question where you can contest the facts.
Yeah.
And talk about the doctrine. Aren't there special circumstances?
I believe that the deviation element in 53E allows the court to, in fact, look at a special situation. I think there will be few, and the fact that there were only 3 cases in the last 50 years that have addressed the appropriateness of a percentage type of order is evidence of the fact that there should be very few, if there are any, that are dealt with like this. But it gives the court the power to deviate when it finds a special situation. The Stanton Abbott case, I think, was a perfect example where it may be appropriate for something like that to be done, because you had a paraplegic recipient of support, you had somebody living in a different country, and you also only made a change with respect to need as impacted upon by the CPI. There wasn't a new consideration of what somebody's income was or what somebody's needs were. It took the need that was established at the time that the order was issued and just adjusted it by 50% of what the CPI increase was based upon some British standard. In the Wooters case, you had a situation where the man went into court about to have prostate surgery and, in fact, contended that he didn't know what his income level was going to be, and the court found there that, in fact, it was likely that neither the needs of the husband or the wife would be able to be met given his particular circumstances, and therefore, when the husband asked for a percentage approach, the court used that percentage approach. The third case is the Draper case, which is, I think, irrelevant at this point in time because we now have rehabilitative alimony, and that's all that that case was, a rehabilitative alimony case. But I do think that, to answer your question just at the end, there are special circumstances, unique circumstances, which the court has the discretion to utilize in order to enter an order where a percentage might be made use of, but not for it to be done routinely, and certainly for not to be done in a situation of this sort, where in fact the number is unable to be determined and the need has been able to be determined. Thank you.
Now, before you go, 53B gives the alternative shall not exceed the recipient's need or 30 to 35%.
Yes.
And you were about to say something earlier as to how we should interpret that.
I would say to the court that that is not an invitation in the context of the entire statute for one to say that the court has the option of either meeting your need or giving a percentage, because you have to go back to the definition of alimony under Section 48. in Section 48, as I said,
Did not interpret it that way. Instead, we should interpret it
as saying that there are two numbers that you calculate. There's a number that you calculate at the time of the hearing, and that is what the need is. There's a second number you calculate, which is 30 to 35% of the difference between the incomes of the parties at that point in time. If, in fact, one's need is less than what the percentage would yield, then need is met. If the percentage is, in fact, if the percentage number that is arrived at is one which is lower than what it is the need is, then you're limited by that statutory provision to provide only the percentage amount. So it's really a definition of the ability to pay. It's a qualifier on need. It's a matter of saying that if somebody has $200,000 of income, and 33% of that is, 33% of that is $66,000, then that is what it is that the maximum amount, in the absence of finding a basis for deviation, is what the order should be, even if the person's need is $75,000. But if the person's need is $75,000, and the person is making $300,000, and $300,000 at 33% is $99,000, then the obligation to pay support is only based upon the amount determined to be the need. And that historically has always been what alimony has been. Not to reward somebody with an asset division, namely, which is a percentage share of what somebody's income may be in the future, based upon their efforts after the marriage ends, but to take the marital lifestyle, to take what the needs are of the person who you're divorcing, and then satisfy those needs if, in fact, the statutory conditions are met.
Okay, thank you.
Thank you very much.
Good morning again, Your Honors. David Cherney, along with my partner, Erin Shapiro. We represent the appellee, Joy Young, in this case. I know there's been a lot of discussion up here about need and ability to pay. I don't think that the Alimony Reform Act changed that. It's still the underpinning and the basic tenet that our probate and family court judges follow when setting alimony. But the Alimony Reform Act did several things, and I think it did adapt to certain situations that we see existing today. Mr. Lee was asked questions about the ability to deviate and what those basic tenets were in Section 53C of the new Act. But Section 53C-9 says, upon written findings, any other factors that the court deems relevant. The Youngs' marriage and the lifestyle they lived together was very unique. They were very blessed through the hard work of both parties, both Mr. Young's financial contribution and Ms. Young's non-financial contribution, to live a life that many of us will never see, many of us aspire to. It's not the norm that goes across the probate and family court on a day-to-day basis, but at the same time, the basic tenets of entering an alimony award are no different just because the numbers may be bigger. Justice Ulwick, in this matter, issued extensive findings. And I think it's interesting that you see Mr. Lee, the first part of his brief, challenges the findings of the court that were made, number 229, that talked about the increasing trajectory level, as Justice Lang pointed out, of the Young's income going up. And he also challenges finding number 324, that suggests that given his 18-plus year history with Fidelity Investments and given his prior history in the financial field, that he wouldn't be that he clearly is in a situation where he's earning more money. This issue of a variable or contingent alimony, I don't like to think of it as a self-modifying provision, as Mr. Lee says, because we have here a very unique animal that I think Judge Ulwick crafted to meet.
That's what it is, isn't it? If it can be $300,000 today and $500,000 tomorrow, if the need hasn't changed.
I think if there was a situation where a finding was made on the evidence that the parties' needs were static, if they had never changed. We see situations where people make extraordinary amounts of money but lead a very meager lifestyle. They don't spend a lot, they save a lot of money, but here the facts clearly demonstrated that their need shifted as the income shifted. It was not static, as was the income not static. They increased their lifestyle. They took advantage of it. Their children went to private schools. They went to private colleges.
So, according to your argument, does the wife have a right to have a higher standard than what she enjoyed during the marriage, which would be what you're suggesting, that if the husband earned more money after the divorce, then her right to that standard of living would continue to rise? Is that what you're saying?
I think
or do we cap this at the moment that the divorce occurred?
Well,
She's entitled to that style
I think in this case, in cases where there is a demonstrated shifting change in need, that it's appropriate for the court to consider that. The Wooters case that Justice Lowy talked about was not just limited to a person who was going in for some surgery and it was unclear as to what he may be able to earn going out. He was a lawyer, and that was one of the issues. But also in the Wooters case, the case talks to the fact that there had been a significantly bouncing up and down level of income of Mr. Wooters as a practicing attorney, that his income, even without the health issues, was never constant, and that's how the parties had lived their lives.
But does it matter that it's the payor requesting the percentage?
I don't think so. I think in that case, it's a little difficult for if you ask for one thing and then you complain that you got it. I think that that's what the court took notice of. I don't think it's a situation where, look, if it's a negotiated case, it's a different ballgame. Oftentimes, we sit and negotiate cases on behalf of clients with fluctuating incomes, and we tie them into percentage incomes, and by negotiation or settlement of a case, we can do that. The issue here is whether the court can impose that. And I think what was said in the Wooters case that was cited, actually was citing, I think, the Stanton Abbott case, they said we should not regard the corresponding shift in the rate of payment as a modification of the judgment, which requires new justification in another court proceeding. The judgment has remained the same, although its variable terms have produced results which in some sense are different.
Can I just, though, follow up on Justice Hines' question, because it's very intriguing. I think most of the time when you think about modifications after divorces, they are in order to take care of the fact that there have been changed circumstances, and usually those are reduced changed circumstances in the part of the recipient spouse. I can't think off the top of my head of one where it is because the recipient spouse wants more money in order to be able to enhance the lifestyle enjoyed during the marriage because the payor spouse earns so much more money that they could afford to do that. Is need always sort of grounded in need at the time of the divorce? As in that, in turn, is reflective of the lifestyle of the parties during the marriage.
I think need is a reflection of the lifestyle of the parties during the marriage, and at the time of the divorce, that's looked at and considered. But where you have a situation where there is a history, and the marital history here was that it was a changing and fluctuating increase in variable lifestyle they maintained. I think that's very different, as I said, than somebody who just sits idly by. There are cases, many cases, where somebody comes in and says, my needs have changed as being a basis for a modification. If a child, God forbid, got ill, if a child had special education needs. We have cases, Brooks versus Paella and Cooper v. Cooper, that talk about maintaining similar lifestyles for both parties post-divorces so that a child won't be living a one level of lifestyle with a recipient spouse and another with a payor spouse. But most of the time when modifications come in, they're because of an event. They're a life event, a changed event, change in job, a loss of job, a bankruptcy, an illness, whatever might be the reason for the modification, a significant change from the facts as they existed at the time the divorce judgment was entered. Here, the facts as they exist at the time the divorce judgment was entered were people who were living a lifestyle and children who were receiving the benefit of that was on an upward trajectory that followed the course of Mr. Young's
Well,
income.
that's not what she said. I thought she said that the earnings were on an upward trajectory, not that the wife was entitled to a lifestyle that was consistent with that upward trajectory.
When you look at the facts as the court found them in terms of needs in the marital history in this case, where the parties went from a certain level of, for example, renting a place in Nantucket to buying a place in
I
Nantucket.
understand that, but I'm trying to get from there to the argument that you're making that the wife is entitled to continue to advance her standard of living even after the divorce. That's what I'm not getting.
Well, in this case, because of it being percentage basis in some years, hopefully not, but in some years it could be a decrease in her lifestyle because it is a percentage base. The point is it ties in with the way people need to adjust their financial lifestyles. If they were living together and married and they were bad, or I should say less prosperous years that he had, the parties would decrease their lifestyle downwards. In good years, they would increase them. They would take advantage of these different things.
Well, so maybe all of that is a good idea, but that's not our law. We have to look at the situation at the time of the judgment, and then if things change, they change. How do you get around the Hassey case where you can't have a self-modifying provision?
I think Hassey was a little bit different because, number one, Hassey, there was a straight base amount. I think it was an set alimony payment based on the first $250,000 that Dr. Hassey earned, and then it was a percentage of his income above that. And in that particular case, they said there weren't findings made by Justice Abbott, by the trial judge at that point in time, to warrant there being a showing that there could be a fluctuating or a non-static increase in need. But Hassey did not say that it's prohibited. Hassey said that what the court needs to do is make findings of the parties' lifestyles, that maintenance of that lifestyle, it's that maintenance of that status quo. Need has always been equated to a lifestyle argument.
So your argument is that the recipient spouse's needs are tethered to the payor spouse's income, whether it goes up or down?
In this particular case, the way Judge Ulwick entered her judgment, it potentially could be. And I think that because if his income went down, then 33% of that decreased amount would be a lesser amount, and she, as Mr. Young, would need to adjust her lifestyle, decrease her lifestyle in good years, save for the years when she might not have to, take out mortgages if she needed to. This is the life that a lot of people in this who are compensated the way Mr. Young is by Fidelity treat and run their lives, because his income is A, so multi-componented, and B, so fluctuating that you really can't fix it today. And that...
See, the problem with that argument is that you're kind of flipping the formula on its head. You're saying, okay, what does Mr. Young earn? Let's work back from that to see what the wife's need is. And that's not how I understand the statute is supposed to work. It's supposed to work the other way around.
I think...
What is the need, and what is his ability to take care of that?
I know you had questioned Mr. Lee about when doing that calculation, that analysis, what do you look at first? And it doesn't say you look at need first and then ability to pay or vice versa. The statute and our case law says you look at need and ability to pay. In most cases, there is not going to be enough ability to pay to meet a need. A lot of times there wasn't enough ability to pay while they were living an intact lifestyle. But when you have cases that are of a higher financial range, or where lifestyles are established that are more significant, and there is that proven ability to pay that.
So you're saying that we treat high-income earners different than we do others, is that?
No, I'm not saying that. I think the principles are the same, Your Honor.
You just said high income.
I'm saying usually, the usual case is that there's not enough money to go around when a case is tried. There's not enough income to support two similar lifestyles as the one had been supported. There are these types of cases where the ability to pay is really not in question. and it's a question more of need. But you need to look at,
Therefore,
well, you have to look at that interrelationship. I'm saying in this case, on these facts, when you look at the changing nature because of the expenditures of the family here, that's what Judge Ulwick looked at and said, it's not fair in these cases that either A, we exclude certain elements that are clearly part of Mr. Young's income, as Catherine Dunn testified to, the Fidelity representative, saying, he doesn't work for just salary, my words paraphrasing, but there's also this ability to take advantage of what had been contributed to during the 18 years these parties were together.
that's not related to how much he should pay. That's a question of how much he can pay. The two things are very different.
I don't disagree with that, Judge, but I'm saying in this particular case, just as was talked about in Stanton Abbott and Wooters, where you have what is really a change in the amount as opposed to the nature of paying based upon the combined analysis of need and ability to pay, that this is a very unique case in that respect, in that there has been this fluctuation and there has been obviously a significant ability to make those payments.
So let me just, let's imagine a family which lived in a 2-bedroom and then moved to a single-family house with 3 bedrooms, and then as the income of one spouse increased, moved to a 5-bedroom house, so their income is consistently and their lifestyle is improving. They get divorced when they have the 5-bedroom house. Need is to be determined as of that time.
Unless you have a circumstance, as I'm suggesting exists in the Young case, where you have them operating on, it's not just the premise of working hard and increasing what it is you earn, but where you are involved in an industry that is based upon ongoing increases, where it's paid and compensated, multi-componented, where you adjust your lifestyle significantly based upon that upward trajectory.
So
That
you're,
it's
so you're
consistent.
saying that if there was, if the judge had set a fixed amount, in my example of, say, $150,000 per year, and then 2 years later, the spouse hits it big, gets a huge bonus, she can go back and say, he's now living in a mansion, I should be living in a mansion because my need should be increasing with his improvement in his income and lifestyle.
That alone, no, Your Honor. If there was an effect on the children, for child support reasons, Brooks and Cooper talks about it.
But why is this case different from my hypothetical then?
Because in the Young case, you have a pattern of increasing lifestyle over 18 years to comport with that income that increases.
You
Your
got
Honor.
it in my example too. They've moved up every few years to
If
a
it was-
larger house.
If it was just an increase in the size of their housing, or just an increase in the types of camps the kids went to, or the schools they went to, any one of those things, no, it's an overall picture that the court has to look at in the whole panoply of Section 53 that defines what the elements are that a court looks at in establishing that amount of alimony payment going forward.
In this case, the kids aren't an issue. They've been educated.
At this point, one of the last one will be emancipated in September, so that wasn't an issue at that point in time.
And would we be in a different posture if he had had a bad year the year before and had received no bonus and his income had fallen materially and could not afford the $450,000 or whatever which was ascertained to be the need? Would there be a different equation there, because his bonuses some year are 0, some years they're $4 million, but this year was a bad year?
Well, if it was a bad year, it would have been 33% of whatever that year would have been. I think that was one of the things that Judge Ulwick addressed in this particular case. The evidence, in fact, stipulated, shows the income rises, it shows the bonus rises. When he started at Fidelity 18 years ago, he had a bonus of $10,000. When we were last in court, it was up to $1.6 million. So these are all.
That proves the fallacy of your argument. If he has a bad year, that has nothing to do with her need. Her need is what it is, whether he has a good year or a bad year.
But just like they did when they lived together, Justice Hines, and they had to adapt their lifestyle up or down, borrow, not borrow, save, not save, cut back, expend, that's something she would have to do as well going forward. I know I have other arguments in here. I see I'm out of time. I rest on the arguments in my brief. I appreciate the court's attention to this.
Great, thank you. And we'll take our